could tell his attorney, and his attorney can tell me what the people to his right look like, what the people to his left look like, I'm going to order the complaining witness to come in and tell me about it and how this lineup was conducted, because I don't think so. But, again, the defendant has a substantial opportunity through his cross-examination opportunity, through his recall opportunity, through his right to present any witnesses that he has discovered or that he has interviewed who he can present some showing of materiality and non-cumulativeness. And after he's done that, and after he's made some showing of why we need to bring in every witness, then he can possibly get the complainant and the victim.
Thank you very much, Mr. Harnish. Lugo versus LJN Toys.
Good afternoon, Your Honors.
Good afternoon, Mr. Berowitz. Isn't the test foreseeability here?
No, that's not the only test. That's the starting point. As this court recently stated in the Ossining School District case cited in our brief, foreseeability alone cannot be the benchmark. If you say that throwing of the toy is foreseeable, therefore, and it causes injury, therefore the defendant must be liable, that cannot be the standard. Then anything is foreseeable in retrospect, more than just foreseeability alone. You're going way back to Paul's graph against Long Island Railroad, foreseeability. The risk reasonably to be perceived defines the duty to be obeyed. Reasonably to be perceived. That's the key issue here. It's not just foreseeability in the abstract. The main question, or the primary question here, is there a duty to warn? That's the first question, all right? Now, if you go to Codling against Paglia and Robinson against Reed-Prentice, you first must establish that the product is defective or it's unreasonably dangerous before you get to the question, is there a duty to warn? There's no duty to warn against something that's perfectly safe. And that's the key issue here, as we see it on this appeal, is whether or not the product here is defective or unreasonably dangerous. We submit that Justice Sullivan was quite correct in his dissenting opinion below that there is absolutely no proof in this record of a defect to the toy.
You said perfectly safe. You don't mean that, do you? You mean not unreasonably dangerous?
Safe. I stand corrected, Judge Hancock. In any event, the question is whether it's unreasonably dangerous or not. Here we submit that the product, the Voltron toy, the assembler toy, was not unreasonably dangerous for its intended use.
Well, Voltron, the defender of the universe. This is a robot which is a warlike figure.
On the television, correct.
With a shield. This toy has a shield which is removable.
Correct.
Is it quite foreseeable that this bellicose toy with this removable shield which could be flung would have just that effect on a youngster, would want to fling it?
The question is, Your Honor, is it reasonably foreseeable that normal children in their normal play are going to take this and throw it? You can say that about any toy, whether they see it on television or not. Unfortunately, kids do throw toys.
Well, true enough, but if it was a Donald Duck toy, you could see where that perhaps it would not be as encouraging as a toy which has this aspect, warlike aspect.
Mr. Butterwitz, if I might piggyback on the Chief Judge's question, in fact, Voltron himself or itself does throw around this object, does he not? That's how he controls the universe.
No question about it that the cartoon...
Well, then why isn't it for an intended use that could be made of this toy?
Judge Kaye, simply because the television cartoon character throws this part around on the television show doesn't mean that's the intended use for the child.
Isn't there even a question of fact? The toy duplicates the television character. The television character removes this object and throws it. The toy has a removable object. Isn't there at least an issue of fact that the object is going to be removed and thrown on the toy as it is on the television?
Not if the answer to the question on whether there's a duty to warn on toy manufacturers to warn children of the common and obvious danger of throwing anything. It's not a question... It's nice to look at the television and say, well, you can glean the conduct of the child coming from that television, but the reality of the situation is that the children throw toys And the reality of the testimony in this case from the child himself, Brian Franks, is that Voltron had nothing to do with it. Not once, but 3 times he admitted in his testimony, I was throwing it. Also, the clear distinction here as well is that duty to warn wouldn't have made any difference here. What are you going to do? Put a sticker on the package or every little piece of the toy? Please don't throw this at somebody. It could hurt them. That's a ridiculous duty that they are advancing because it's not going to change the common and obvious risk here. Every little toy piece or every little toy thing has to be labeled. That's stretching it too far. And in effect, if you hold that that duty is applicable here, it makes my client an insurer of a little boy's misuse of a toy product, especially when they, again, have not shown that the product here is defective. They're trying to say it's defective because of this cartoon character, and that somehow influenced this child when the testimony is clear and unrebutted that it did not influence this child. That's the key. If you look at their experts' opinions, what they tried to do was impeach Brian Frank's testimony. Oh, he really didn't mean what he said. He could have been influenced by it. But they have to establish the legal cause here. It's their burden to prove legal cause, and we've shown by the testimony that there was no connection whatsoever here. Turning to the issue of legal cause, I'd just like to note the recent decision by this court on November 30th, the joint decisions, the Kriz against Shum and Dankinson against Davenport cases, which is this court decided about the pool diving cases. One was off the belly slide, and the other one was diving off. I believe Judge Alexander was the...
We're very familiar with it, Mr.
Turning to that one, now we rely to some extent on the other cases in our briefs, the Howard against Poseidon pools. We said Brian Frank's act here was the superseding cause. Now, for the first time in Kriz and Dankinson, this court distinguished those cases. It is our position that it was reasonably foreseeable to use the slide in Kriz to go down it. As a matter of fact, the manufacturer advertised it that way. But to say here that it was reasonably foreseeable for this kid to throw the toy against what his parents had said, against what his teachers had said, and what he knew from his own common and obvious experience, that's the distinguishing factor between this case and those cases there. Additionally, Your Honors, that with respect to, we say that it's also, this was not foreseeable in the normal course of the events. The key case relied upon by this court in Kriz and Dankinson from the end of November was Didarian against Felix Contracting Corp. And as this court stated in that case at 51 New York 2nd, 315, the liability turns on whether the intervening act is a normal or foreseeable consequence of the situation created by defendant's negligence. How can you say that the throwing of the toy part here, or throwing of any toy, was created by the defendant? Especially when on this record, the proof is unrebutted that this boy was not imitating Voltron. Voltron had nothing to do with it. That is Voltron, the television character. We have no proof from the experts here, submitted by the plaintiffs, that this product was defective. The only standards to be followed were the federal ones. In trying to rebut that, they come up with the theory of a toy safety community. Very interesting, though, if you read Ms. Ridenour's affidavit, they're experts, what is the toy safety community? She doesn't tell us. What are the standards to be followed by any toy manufacturer in supposedly meeting this? She doesn't tell us. And finally, she doesn't tell us how we violated these nebulous standards. So I don't see how we're going to be required to defend a case when against standards that are up in the air. The only standards that are there, we have proved we met, we complied with, the federal sharp edge and sharp point requirements. It's not a preemption argument. We didn't argue, oh, the federal rules are out there, it preempts common law. It's simply a matter, look, this is what they claimed against us, that we violated this. On summary judgment, we have proved we did not violate it, and they didn't meet their burden under Zuckerman and Friends of Animals, come forward with proof to defeat our showing. That's simply the point. Finally, Your Honors, we submit that this court should easily see this case for what it really is. It's a products liability case where plaintiff has not shown a defect, nor that the injury here was the result of a reasonably foreseeable misuse, and where Voltron cartoons really played no part in Brian Frank's act here, which unfortunately he did in total disregard of the common and obvious dangers involved. Thank you, Your Honors.
Thank you very much, Mr. Budowitz. Mr. Fitzgerald?
Thank you. Good afternoon. If Your Honors please, we're here on a summary judgment motion. It is our position that there should be a trial of all of the issues raised here. Defense raises the issue of intended use, says that this was a misuse of their toy, and its third point is that the videos cannot be considered a proximate cause of the injury. All of those are jury questions, and we don't think the court need go any further than to decide the case on those narrow grounds. However, with respect to intended use, and with respect to this toy safety community, the record also indicates that Mr. Morehouse, a defendant's employee who designed this toy, acknowledged that children do indeed fantasize, stated that when designing the toy and its possible uses, he relied on his extensive experience in the industry, but stated, however, that he doesn't know whether or not children play with toys always properly. We think there's a real question as far as intended use goes here. Our expert on toy safety, Ms. Ridenour, stated that the defendants failed to maximize the curvatures of this particular object, the throwing star, and that they failed to use a softer material given its foreseeable use. Defense has stated that any toy can be thrown, and indeed the dissenting opinion at the appellate division states that any toy can be thrown and injure a child. However, it is our position here that it is much more probable that this toy would have been thrown, number one, and that would cause injury. When you design an object with 8 starred points around it and toss it, and it comes in contact with sufficient force with soft tissue, it becomes all but impossible not to cause an injury. We don't think it's the same as throwing almost any other toy. Let me, if I may, address what I consider to be 2 public policy issues which are raised in these briefs. In the first place, we submit that it is this court's public policy to protect our children from danger. And we cite Collantine, in which the propensity of children to roam and climb and play, Cush versus the City of Buffalo, in which an 8-year-old struck a match to chemicals which were not properly safeguarded before he injured himself, and Henry versus Crook, a 3rd Department 1922 case, in which they state as follows: these sparklers, however, were intended for the use of children of tender years, immature, who are not chargeable with understanding, sense of danger, and prudence, young children who must be warned of danger. We think those words ring as true today as they did then. Now, each of these cases and others have 2 things in common. Number 1, they involve children. And number 2, we submit that in every one of those cases, the result would have been different had the actor been an adult.
Mr. Fitzgerald,
Yes.
Go ahead.
we have some pretty strong evidence here of the lack of causation. Why should this go forward to trial?
Lack of causation of the injury, Judge, or the
Lack of causation of injury. This child had not seen Voltron or was not influenced by Voltron. He knew he was not supposed to throw the toy. In fact, he did not throw it when the other child was present in a place where he might hit the child. Why can't we say that there was no causation as a matter of law?
Well, because, if Your Honor, please, that he had viewed the videos, number 1. Number 2, defense counsel has set up Brian Franks, an 8-year-old, the actor who threw the toy, as a combination of the one who is to decide what the intended uses were, and we submit that intended uses in all aspects of Monday morning quarterbacking here. We don't think that you can ask an 8-year-old after an injury has occurred what was the intended use before the injury. We also feel that it is a jury question as to whether or not what Brian Franks was in fact actually doing. It's interesting to note that the dissenting opinion in the appellate division raised Brian Franks' statements to an admission. They say he admitted, well, he's not a party, and we don't think that the plaintiff should be out of court simply because an 8-year-old actor makes some statements. We believe that a trial is required to fully flesh out this, and we believe that a jury can indeed listen to competent testimony from a child psychologist and from those who design toys to decide whether or not there was in fact causation. But once again, with respect to intended use, that's not the issue really. We will argue the aspect of intended use, but it's really foreseeable. It's not whether or not this product was intended to be used.
I'd like to ask you a question, if I may, on what you claim the defect is.
Yes.
As I understand it, there are 3 components to your argument. One is that the object, the shield or whatever you call it, was small and removable.
Yes.
2, that it was sharp.
Yes.
Or had some sharp points. And 3, that it was the subject of the Voltron TV program.
Yes.
My question is this: if you remove the second element, namely the sharpness, is it still dangerous? Is it still something that requires a warning? Because, of course, even without sharp edges, or even if it were completely round, it could still hurt somebody. It could
Yes.
stick somebody in the eye. Is it still
I think
Still
we would. I
dangerous?
think we might have to take a look at cause and fact there. It might depend on the type of injury that was inflicted. Yes.
Well, yeah, but danger in the type of case that we're talking about has to do with the nature of the product, and that's what I'm asking about, not about the injury. And of course, we know that any toy, any object, whether it's round or whatever, can seriously injure somebody if it strikes somebody in the eye. So I guess that my question has to do with what is there about this particular object being part of a toy which makes it so dangerous that it requires a warning?
I think that we have to take a look at the nature of the particular product itself and the configuration of the product and the test.
My particular question is, leave out the sharpness. Let's assume it's perfectly round and not sharp. Is
Well,
it still
if
dangerous?
if it were a Smurf ball, if Your Honor please, I would agree with you that it might not need to be warned. There might not be any warning necessary. But I think that we need to see that, and the test is it one whose utility does not outweigh the danger inherent in its introduction into the stream of commerce? Quoting from the last part of the statement in Robinson versus Reed-Prentice that counsel referred to, we submit that there is not one iota of evidence here as to the utility of this object. We don't think that children needed another warlike object to play with, and so we therefore
There's
submit.
not much utility to many toys
But they're not as dangerous. They're not as dangerous.
Of the parents, anyway.
But this wasn't a Ken and Barbie doll either, another Ken and Barbie doll, if Your Honor, please. It was a warlike toy
Well, if
with
you threw
martial arts.
If you threw a Ken and Barbie doll, that could be dangerous too.
Yes, but I don't know of any videos, if Your Honor, please, that depict Ken and Barbie having at each other.
And they don't defend the universe,
They
right?
don't. Or do they have? Do they have spinning laser blades, Judge?
You haven't watched Mr. T, obviously.
Huh? I've watched Mr. T, Judge. Again, with respect to intended use, the appellate division clearly points out that on this package there were neither warnings nor any directions for recommended use. There was nothing. We do know that there were the videos that the children watched and that Brian Franks in particular watched. And so when we go to intended use, we think that the only thing before the court is what is contained in the videos.
Thank you very much, Mr. Sheriff.
Thank you. All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence and appear here tomorrow afternoon at 2 o'clock, at which time this Court now stands adjourned.